Khyber Pakhtunkhwa. Advocate General Khyber Pakhtunkhwa, Your Honor. I was put on notice in this very case, Your Honor.
Okay, and who represents respondent number 1 and the National Accountability Bureau number 2?
I'm here, sir. Prosecutor General, sir.
And for 1?
For 2, sir. National Accountability Bureau, sir.
ये 1 के वकील कौन थे पहले?
Khaja Haris.
हाजिज हारिस साहब किधर हैं?
My lord, he has not appeared in the appeal in paragraph 6 of your lordship's order.
Paragraph 6.
6, my lord.
Pardon?
My lord, on 11th October, this court had announced the order in Constitution Petition 6/2023. However, detailed reasons have not been given as yet. Therefore, it would be appropriate to fix these appeals after the release of the detailed reasons in the said case. However, to save time, let notice be issued to respondents. Since the interpretation of Constitution, federal laws, and as trials, which the amendment had referred to courts in the provinces and to the ordinary courts in the Islamabad Capital Territory, which has been reversed by the impugned judgment, notices be issued to the Attorney General for Pakistan at the Advocate Generals and all the provinces in the Islamabad Capital Territory be also issued under Order 27A of the Code of Civil Procedure 1908. Copy of the order passed to accompany the notices. The incarcerated respondent be served through the concerned jail superintendent and be provided copies of the appeal. And if he wants to be represented, the jail superintendent should do the needful.
ठीक. Attorney General, are you supporting the appeals or opposing the appeals?
My lord, I am supporting the appeals.
The other Advocate Generals, NAB is supporting or opposing? NAB is supporting or opposing?
I will adopt the arguments of the Federation, sir. What is the stand of the Federation? I will adopt.
The other Advocate Generals, Khyber Pakhtunkhwa?
आपकी तरफ से भी adopt कितने में लो?
Khyber Pakhtunkhwa?
Your Honor,
Are you opposing or supporting?
we would be जो order पहले हुआ है impugned order को, we would supporting that very order.
So you'll be opposing the appeals?
Yes, Your Honor.
ठीक है. And Sindh? Ajay is supporting the appeals. And Balochistan? So Punjab is supporting. तो रह कौन गया?
Balochistan.
अच्छा बलूचिस्तान से फिर हम पूछ लेंगे. ठीक. Okay. Are you ready to proceed?
My lord, yes.
You will proceed first or Mr. Farooq Naik will proceed first? आपस में आप लोग फैसला कर लें.
Isme, we have been informed that one of the respondent was served and he wants to appear in person. Mr. Imran Ahmed Niazi was the petitioner.
इसमें हमने लिखा था, and if he wants to be represented,
My lord.
the jail superintendent should do the needful.
Right.
This is a matter of law. So we want to restrict it to a matter of law. I don't know what a private person.
Speaking for myself, he was a petitioner and is one of the respondents. And since we had passed an order, if he wants to appear in person, arrangements have to be made.
आप क्या
How
कहते हैं?
can we condemn him unheard?
My lord, in the original proceedings, he appeared through counsel. So Khaja Haris represented him in the original proceedings, and now the matter has come up in appeal. So I don't understand how the respondent.
This is not for your understanding. This is for the understanding of the respondent. Whether he wants to appeal,
I am just.
he wants to engage a counsel.
Of course, but there is nothing so far. I haven't seen it on record.
No, but he's one of the respondents. How can we deny him access to the court?
Of course.
Your Honor, yes.
Yeah.
तो ये आज ही हमें भेजना था. पहले नहीं आ सकता था. ये कब आया हमारे पास?
ये तो ऑफिस ने हमें दिया है.
ये तो मुझे अभी कोर्ट में मिल रहा है कुछ.
ये कब आया? ये रिपोर्ट कब आई इनकी? Notice का reply.
At the first stage, my lord, the matter was heard for about almost a year. And throughout the year, Khaja Haris Ahmed Sahab
That
represented.
is understood, you
My
see,
lord.
since it's a matter that involves, NAB, which has been perceived as being involved in political engineering, so wants to appear in person, how can he be denied access to the court?
It's entirely a matter for your lordship to determine.
नहीं, आप बताइए ना, would it be fair?
My lord, your lordship can, because it's a matter of law, either give him time to engage counsel or allow him video link if there are other problems in
Yes,
terms of appearance.
Even if he wants to appear through video link,
Yes.
but we can't deny him access.
It's for the learned Attorney General, my lord, to answer.
My lord, ultimately it is going to be your decision how you wish to.
He may be, you see, he's also one of
He's a
the respondents. So
I'm not.
The issue is very
comment on-
simple. This is not a matter of personal rights.
It's a violation of
It's a
law.
matter of a varies of a legal amendment.
Yes.
Right? Now, if we are being used for other purposes, fine, that's okay. But it's not a matter of individual right or individual, I'm affected by this law. And the law, last order had specifically stated that had set out the reasons in paragraph 5 that it is a matter, and if he wants to be represented, the jail surgeon should do the needful. Okay, now this, where a matter of pure constitutional law and the ultra vires or the intra vires of a amendment is to be sought, will we be assisted by a person who's not a lawyer? Yes. If there's a personal rights is infringed, fine. Then in all cases, the person should also do the same thing, and not just because it's here it is an appeal from a judgment where the law points were being discussed. And they were being discussed by counsel, and there were how many counsel representing Khwaja Haris, Dr. Yasir Aman Khan, Mr. Isam bin Haris, Ms. Zainab Chaudhry, Mr. Muhammad Hashim Bakar, Barrister Faiza Asad, Mr. Muhammad Shoaib Ilyas. Right, I have no problem on representation, but if it's to be it's to be used for some other purposes, then it's a matter which we need to consider. I mean, will we be guided by a layman, particularly when he has no interest in the matter, in the sense it's a matter of law. Either we uphold the judgment or we set it aside the judgment, that it is ultra vires or intra vires the constitution. That's the question before us.
The original
My lord,
petition was
Why
under
is Mr. Haris not even here?
My lord, may I make a submission? My lord, in the petition was even challenged before the improved judgment regarding the maintainability of the petition, whether the issue involved in the petition is of public importance or not. And the question of public importance can only be answered in the legal and the constitutional framework by a lawyer and not by an individual.
There's no
There is
provision.
but if there is a person has some personal stake in the matter.
There is no personal stake. They say this is a
अच्छा, हम
petition
ऐसा
of.
करते हैं, okay, but we will एक second, we will adjourn for 5 minutes and we'll discuss it amongst ourselves. आइए इनको बुलाएं. चलें? Represented, and he was a petitioner before this court, and it is a judgment that has been passed is impugned, the majority judgment. So since the petitioner, and since the National Accountability Bureau is supporting the appellants, then there won't be any contest in the classical sense. So we would want to hear the other side. If the respondent wants to argue the matter himself, if he thinks he can attend to these complex constitutional questions, that's for him to decide and not for us to decide. So we are allowing the request, but we would then you'll have to make arrangements for what is it called? Video link, wherever he is. And the video link, please have it tested and all that. So when we assemble, we don't want any disturbance. The video link facility, how you want to arrange it. And I don't know if the copies of the petitions have been provided to him or not. ये इसमें बताया कि देखें copies. हाँ?
इसी में हमने 5 volume.
Yes, they have already been provided. See, but since there is a stay and this matter is pending for some time, we don't want to have a long day. So how soon can you make arrangements?
My lord, next week perhaps. I mean,
No, next week I won't be here. Then it will get delayed. परसों नहीं कर सकते हैं?
सर परसों मैं चेक कर लेता हूँ आपके यहाँ पे होगा जो आई थिंक इसमें
आप अगर पूछ ले मैं बता
चेक करना होगा हाँ ठीक है मैं फिर ये चेक कर लेता हूँ कि कितना टाइम लग जाता है रिपोर्ट
आज हमें बता दें क्योंकि अगर हो सके तो फिर परसों से कम से कम आगाज तो कर लें
ठीक
या दूसरा तरीका ये हो सकता है मखदूम साहब अगर आप आज आप आगाज कर लें तो आपके कोई कंटेंशन हम रिकॉर्ड भी कर लें कि फिर रिस्पोंडेंट नंबर 1 को पता तो हो कि आपने बहस क्या की है तो वो उनके लिए भी सोचने का वक्त मिल जाएगा कि ये आपके लीगल कंटेंशंस अगर आप प्रिसाइज कोई लीगल कंटेंशंस फॉर्मुलेट कर लें
बल्कि बहस की बजाय अगर आप कुछ पॉइंट्स बता दें ताकि उस पॉइंट्स को रिप्लाई करना बहस बाद में करें
encapsulated in a few propositions.
जी
And if your lordship wants-
because that will also help the respondent number 1 to respond.
My lord.
Is that all right? नहीं, Mr. Just
Sir, yes, I can begin to do that straight away.
So then we will allow his request, and we will try to incorporate whatever you say today. And actually, you may want to add something later, but then he'll be hearing himself. But it will give the respondent number 1 time to
Or if you-
absorb and respond to them also.
And if your lordship wants to facilitate him further, I can, instead of, and to save your lordship's time, instead of submitting that orally, by early tomorrow, give a list of propositions in provided to the court staff, and those can be communicated to him, whichever way your lordship pleases. I can articulate them now, or I can give them in writing by tomorrow morning.
नहीं तुम सब हम तो देख लेना
जी सर,
देख
मैं
लें
अभी
और हम
submit-
आगे ट्रांसमिट करते
जी,
हैं
जी,
नहीं, आप ऐसा करें, can you just since we've assembled, we don't want to waste
Sir,
this day.
I will-
We may do both.
By law.
We may also then call upon you to write them down later.
My lord.
You may want to think, but so can we hear you
My lord, yes.
on the fundamental questions?
My lord, let me begin straight away.
Don't go into the facts,
No.
just the legal proposition.
Just the legal proposition.
Makhdoom Sahab,
Sir, my lord.
speaking for myself, there's one appeal by the federal government
My lord.
and the others are by private person.
My lord.
Section 5 of the Act जो है, Practice and Procedure, my understanding is that only an aggrieved person can file an appeal. So how is the federation aggrieved?
My lord, because a statute of the federation was struck down.
Sorry, आपका आवाज.
My lord, 2 reasons. One, the federation was the respondent, and it was a statute, federal statute, which was struck down. So if the federation is not a respondent, then in that event, in a situation like this, where NAB didn't come forward as an appellant, then virtually every decision made by the court would be final and there would be no right of appeal. And your lordship knows that even if we move away from 184.3, wherever statutes are struck down under 199 by the High Court, constitution petitions are filed under Article 185 of the Constitution and have been heard by this honorable court, and the federation has never been non-suited on that ground.
Here we have to interpret Section 5 of the Practice and Procedure Act.
Yes, ma'am.
Subsection 2
Yes.
was in fact struck down by this court.
Yes.
But when you read subsection 1 and subsection 2,
Yes, my lord.
it is an aggrieved person. And this court consistently has interpreted the expression aggrieved person as a person who has suffered a loss. A department or the government has not been treated as an aggrieved person for the purposes of an appeal.
If your lordship may see section 5.
I think there are two slight variations to the proposition. The first variation is any party to litigation, if a case is decided against him, will be presumed to be an aggrieved person. There may be third parties who may come forward and say, I'm aggrieved by this person. In my opinion, those persons will have to show how are you aggrieved, as opposed to every petition that is filed, I'm aggrieved by this judgment. We don't delve into the question, how are you aggrieved by this judgment if he's a party? If he's not a party, then HM Saya principle applies or not. Then we ask him how you aggrieve. You are a party, it is taken that you are an aggrieved person. Otherwise, that party would not have been arrayed as a party to begin with. So why did the petitioner make him a party?
On same principle, we are allowing the respondent to appear to argue the matter.
And may I also...
One thing more, Mr. Who proposed these amendments to the parliament?
My lord, I'll come to that in a moment. May I just draw your lordship's attention to section 5 itself, and your lordship will see that the word aggrieved person is missing from
But
there.
the fact is, again, this debate will become academic since you are one of the petitioners yourself. There are the private parties as petitioners themselves.
Yes, my lord.
So can we have your propositions?
My lord, yes.
Ji.
My lord, my first proposition before your lordship is that during the pendency of this petition, the Practice and Procedure Act of this honorable court was enacted, and with that inaction, we made...
Even if you now you come back to the Practice and Procedure Act, please read section 5.
My lord, yes.
Sure.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And that's what I was submitting. That your lordship
And please read subsection 2 as well.
subsection 2, which has now been...
It has not been upheld by majority.
Yes, the right of appeal under subsection 1 shall, and I emphasize the word, also be available to an aggrieved person against whom an order has been made under clause 3 of Article 184 of the Constitution prior to the commencement of this.
So it's only not part of this statute.
It adds the aggrieved person, you say? It adds the aggrieved person.
It broadens the definition.
Yes, my lord, but the word also, and your lordship will know that right from Fazaldeen's case in 1969, even the definition of an aggrieved person, which now is there under Article 199 of the Constitution, this honorable court in questions relating to fundamental rights has taken a relaxed view of that. And one of the principal distinctions being pointed out between 199 and 184 3 is that under 199 you have many of the other trappings, as they are called, where the court can regulate the jurisdiction. The word aggrieved person is missing from Article 184.3, which is there under Article 199. My lord,
Isme Makhdoom Saab, this is a statutory appeal.
My
Now,
lord, yes.
Statutory appeal mein,
Yes, sir.
in case of Customs Act, there are 3 judgments of this court, 3-member benches, where the Custom Act only then had provided a right of appeal either to the collector or an aggrieved person.
Yes, my
The
lord.
Director Intelligence had filed an appeal, and this court held, and it was the argument of director that I'm an aggrieved person. This court held you may have been disappointed with the judgment or the order, but you cannot be an aggrieved person because no personal loss has been suffered. That is how this court, in case of statutory appeals, has interpreted an aggrieved person.
My lord, there's a fundamental distinction. The fundamental distinction is between a statutory appeal arising out of a statute and a statutory appeal arising out of a constitutional remedy against which previously there was no appeal at all. If this interpretation is accepted, and if under Article 184(3), this Honorable Court strikes down any statute, that would mean that there would be no right of appeal at all to the Federation. The other distinction is that over there, it was the officer concerned who had come up in appeal. Over here, it is not the current incumbent Prime Minister of the country, or a particular official, or a Director General of NAB in his personal capacity who has come before your Lordship, CPC. The person who has come before your Lordship is the Federation. If the Federation does not have a right to defend its statute, then who else would? And particularly in a case, this was a case where the petitioner had come to this Honorable Court. There was no real controversy before this Honorable Court. The petitioner had not been affected by the operation of any of the provisions of the NAB law. The petitioner had not suffered any grievance against any of the provisions of the NAB law. He had raised, and that's the submission made, which didn't find acceptance by the majority. The petitioner had raised an issue, and the issue raised by was that this violates the fundamental rights. He never maintained that it violated his fundamental rights. He made the Federation a party. The Federation.
Can we go with the propositions? Otherwise, we will not make any headway.
I've only raised a question. आप इसको बाद में देख
Absolutely, my lord. Everything which your lordship says merits and is worthy of immense consideration.
But
And I
our
will,
propositions, Zakir, because
my lord.
the respondent number one is not hearing this.
my lord,
He may want to hear this.
My lord.
If you formulate the proposition,
my lord, I will.
then we can send the propositions and then
My lord, the very first proposition is that during the pendency of the petition, the Practice and Procedure Act was enacted and an application was moved before the Honorable Division Bench that this matter should now be placed before the Committee for Constitution.
please refer to that application.
My lord, I will. I will. My lord, may I just give your lordship the date? This statute came about on 21st of April 2023. The Federation filed CMA 7066 of 2023.
70.
66 of 2023. This is dated 28th of August 2023.
Where will we find it? Which page?
My lord, and your lordship will find it at page 402, part 3 of my intra-court appeal.
Four zero.
402, my lord, part 3 of my intra-court appeal.
Where's the order on this one?
My lord, the order was passed by this honorable court
So
on,
first, let's read the prayer.
yes, my lord.
Then
427 onward, but let me just point out, your lordship will see on page 402, I produced a note. If your lordship will see page 404, I make a specific reference to SCPA 2023. Its provisions are reproduced on page 404. Case law is cited in support in 406 and 407 and 408. I make other submissions as well, and I'll come to that later. And then your lordship will see the prayer. It is most humbly submitted that the page 413, that the proceedings in the present petition may kindly be adjourned till after final decision in Constitution petitions number 6 to 8 of 2023 regarding validity of the SCPA 2023, or alternatively a full court be constituted to hear this petition.
and the order on this application.
My lord, the order is at page 427, which is in part 4. It's a split.
427,
my lord, part 4.
Page 427.
427.
427, my lord. My lord,
Actually, I had not read this order.
Sir.
So can
if you
you
lordship-
read the relevant bits that you
Yes, my
think
lord.
are relevant?
First is my submission on page 427. Your lordship may
No, right, just operative part of the order. But
the operative part of the order, my lord, paragraph 4 on page 429.
429.
Paragraph 4. Be that as it may, we are not inclined to comment on the vires of the Procedure Act, which is a matter for the 8-member bench seized of constitution petitions number such and such to decide. It would be clearly presumptuous of us to assume the outcome on the above issue. However, it should not be ignored that the Procedure Act has been suspended by the orders of 13th of April 2023 and 2nd of May 2023 passed by the 8-member bench. The federal government thereafter in the hearing has neither requested for the recall of these orders nor for their modification. Consequently, so long as these interim orders are in the field, we are of the considered view that the same must be complied. The title Constitution petition has already undergone nearly 50 hearings. Its proceedings have reached the final stage and are near conclusion. The said petition should therefore continue to be heard and decided by the present bench. Any change in the composition of the bench is neither necessary as a matter of law or of propriety, nor is it advisable at this end stage of the case. Indeed, including the case would serve in the public interest as much of the time and public money have been expended in hearing the instant petition. There is a dissent, my lord, at page 431. And if your lordship may see the opening paragraph by my lord, Mr. Justice Syed Mansoor Ali Shah, I raised the following question during the hearing of this case on 18th August. Whether this bench should continue hearing this case or should this case be adjourned till the court first decides the constitutionality of the Supreme Court Practice and Procedure Act 2023, or in the alternate, should a full court hear this case pending decision on constitutionality of this court. Then his lordship gives the reasons what transpired that day. Paragraph 5, his lordship refers to my submission. The Learned Counsel for the Federation has argued in favor of adjourning the hearing of the present case till decision on the constitutionality of the Act, or in the alternate, constituting a full court bench to hear it, mostly for the same reasons as recorded in my last order and reiterated above, and no satisfactory answer has been put forth by the Learned Counsel for the petitioner to the proposition recorded therein, that if ultimately the court upholds the constitutional validity of the Act, any decision given in the present case by this bench, which is not constituted as per the procedure prescribed in the Act, and of the strength of judges required under the Act, may arguably be quorum non juris and thus a nullity in the eye of law. The order of my learned brothers I submit most respectfully does not address this concern either. Even they note in their order that it would clearly be presumptuous of us to assume the outcome of the above issue. The decision of the constitutional validity of the Act is an equally possible decision with that of its constitutional invalidity. It is not a presumption or speculation. No one can be sure of either of the decisions before pronouncement of the same by the bench concerned. Further, it is not the matter of compliance or non-compliance of the interim order passed by the 8-member bench, which is only of temporary nature. The real concern is the effect of the possible final outcome of the constitutional validity of the Act on the present proceedings and any decision given therein. There's a possibility that the instant proceedings and the decision given therein may become quorum non juris and a nullity in the eye of law if the constitutionality of sections 3 and 4 of the Act is upheld by the other bench. So this Damocles sword hanging over these proceedings can easily be removed if either we await the decision of the 8-member bench on the constitutionality of the act or make it ineffective by placing the matter before a full court bench. The interim order of the 8-member bench suspending the act was passed on 13th April 2023, more than 4 months ago, and there is no next date of hearing fixed in the case. This unnecessary delay in adjudicating a matter which directly deals with the core functioning of this court is not understandable, considering that almost 50 hearings have been held in the instant case. It therefore doubly requires that the constitutionality of the act be decided first as the earliest, so that the court can function in accordance with law rather than under the uncertainty of a stay order. I therefore maintain my earlier view in my note of 22nd June 2023.
What was your ground for constitution of larger bench or for staying the proceedings?
My lord,
Your ground, what on which?
my lord, section 3 and 4 of the Practice and Procedure Act.
Four talks about interpretation of constitution. Whether any constitutional interpretation was required in this case?
Yes, my lord, because they were asking for the striking down of several procedures, provisions of the NAB Amendment Act. They were on the touchstone of the Constitution. The argument being made was that it violates a number of provisions of the Constitution, the provisions relating to fundamental rights, provision relating to Islamic provisions, provisions relating to power of an authority of parliament, provisions relating to virtually how a power is to be exercised. All of those were in question.
There's also another ground, speaking for myself,
My lord.
where a larger bench should have heard this case, and that was the question of maintainability, because in high courts, certain petitions were pending, challenging the vires, and the judgment of the majority did refer to the Benazir Bhutto's case, PLD 1988, Supreme Court 416, which is, I believe, an 11-member bench.
My lord.
And that is the law till today.
My lord.
And again, this court is ignoring that law. So either that was binding and had to be followed. So any departure that was required to be made had to be heard by a larger bench.
My lord,
So that is.
may I respectfully am very grateful for that observation. I had spent an entire day arguing Manzoor Ilahi and arguing on the basis of Benazir Bhutto and pointing out that there was a petition pending under Article 199 of the Constitution before the Islamabad High Court, and in view of the pendency of that petition and in view of these two judgments.
You see, regardless of that, Makhdoom Saab, with great respect, the larger bench judgment is binding even on this bench, because that's an 11-member bench.
Yes, my lord.
And Manzoor Ilahi's case has been reaffirmed by
my
them.
lord. Yes,
and
my
that is the law.
Yes,
and
my
that law is again and again ignored.
Yes,
and that was also ignored in the election matter, to which the majority has made a reference.
My lord, yes.
So that could not have been overruled, and till that is not overruled, 184(3) petitions are not maintainable if matters are pending before the high courts.
My lord, even before the Practice and Procedure Act was enacted, that was a submission made by me before the Honorable 3-member bench of this Honorable Court. And that was my next point, which your Lordships has encapsulated far better than I could.
Arguments, we will hear you later. This is your main arguments.
My lord, that's my second argument after the Practice and Procedure Act. The second argument,
What is the first?
my lord, the first was that in view,
What is the first proposition?
the first proposition is that in view of the provisions of the Practice and Procedure Act 2023, the proceedings before this Honorable Court's 3-member bench had become quorum non judice, and the matter should have been referred to a committee.
So are you saying this judgment is a nullity in law?
That's what I'm submitting, my lord.
What do you say about when the Practice and Procedure Act was suspended? It was not in field.
My lord, your lordships knows it better than me that an order of stay operates inter partes. It operated between them, and my lord, Mr. Justice Syed Mansoor Ali Shah refers to my submission and encapsulates this very well, that if tomorrow this Practice and Procedure Act will be upheld. The stay order will be vacated. And for that period,
So you were prescient or was just a sharp prescient?
my lord,
Or
this is,
both of you?
the members of this honorable bench are always prescient.
Makhdoom Saab, speaking for myself, the petition was not maintainable in the light of the law laid down by the Benazir Bhutto's case.
My lord, and that was my submission even prior to the 2023 Act, because the Act came in between. And
पहले
that's
ये
my-
एक proposition हो गया, अगला
Sir,
proposition
अगला
क्या है?
proposition ये है कि on the same issue, a constitution petition under Article 199 of the Constitution, being petition number 2557 of 2022, challenging the law, was pending before the Islamabad.
So I'm just thinking aloud, don't read too much into my observations. It could be that a petition comes here and someone just to stop that files a petition in the High Court. Okay, it could be completely mala fide. Okay, how would we know it? We can't know mala fides and bona fides, and that would happen. So should that not be a matter of case-to-case basis just because a petition has been filed? Or, for instance, some things are time-related. Like, you know, it's very important something happens and a party is not interested in adhering to a certain time. Let's take elections, for instance. So they file a petition, one in Baluchistan, one in Sindh, वगैरह, and someone files who's actually interested in elections in the Supreme Court. So the Supreme Court should say, hang on, let's debate those. So they will effectively get the relief what they wanted, delay. So should it be binding on us to that extent, or we have to actually consider the merits of each case, whether in this matter, we should await the decision of the High Court? No, the heavens won't fall. We can easily await it. In some other matter, no, we must proceed immediately and decide it.
My lord,
or is there a hard and fast rule we have to follow?
no, my lord, even in Benazir Bhutto's case,
We want to hear your view.
no, may I just point out what this honorable court has observed? In Benazir Bhutto's case, their lordships described the principles in Manzoor Ilahi as the salutary principle, but in the facts and circumstances of the case, did not follow that route, did not pursue the route. They created a distinction. So what your lordship is observing, your lordship will look at the facts of the case, but over here, it was not a case where to divert the proceedings from this honorable court to the Islamabad High Court. This petition was filed. The Islamabad petition had predated this. That petition was filed by the Islamabad High Court Bar Association. It was not filed by any surrogate petitioner, and it was pending the hearing, and that objection was raised at the very first stage before this honorable court that the Benazir Bhutto's case applies.
Benazir Bhutto, we're talking about the election matter.
Benazir, no, my lord,
Which Benazir Bhutto?
my lord, the political party's case, the first case,
Makhdoom Saab,
that is
my lord,
1988
this is
Supreme Court
Halim
416.
Halim Saab wala faisalah.
Yes, my lord.
ठीक.
My lord has rightly pointed out and very eloquently in Benazir Bhutto's case, these concerns have also been addressed
Yes, my lord.
and addressed at length and very eloquently.
Yes, my lord.
That when a petition under 184(3) will not be taken up.
Yes, my lord. Yes, my lord. And their lordships in that case, as your lordship knows by your lordship's detailed reading of the judgment, have evolved the doctrine of effective pendency. That if what the High Court was doing was virtually not proceeding with the case and virtually frustrating those proceedings, then not proceeding in the Supreme Court would not be countenanced by this honorable court. It was submitted that that was not the case over here. To the contrary, after filing the petition in this honorable court, adjournments were being obtained from the Islamabad High Court that now that we have gone to the Supreme Court, please don't proceed over here. So it was an altogether different situation, and that is why it was relied upon.
Let me clarify one thing from you. If, there's a big if, capitalized big if, we accept, for the sake of argument, don't think we have, this quorum non judice. Are you just relying on that ground, and then the petition in Islamabad High Court gets revived, and we just stop?
My Lord,
Or are you also going on the merits?
My Lord, I would, as a council does, I would raise these 2 or 3 preliminary submissions, and I would also show to your lordship that even on merits, the petition was not maintainable, and I will identify them also in one-liners before your lordship. My Lord, besides the second submission, the third one was that this was a unique case in the common law history of constitutional countries. There is no similar case, and I had made that submission, and the counsel for the petitioner did not come up with a case. My submission was that this was the first case of its kind where the petitioner in the petition itself, the petitioner himself had said that he himself had passed this law through various ordinances. And much of what had happened in the 2022 Act was incorporating what he had done through ordinances.
Are those ordinances on record?
Those ordinances were on record.
Are on record.
And,
Yes, my lord.
and they have been also,
maybe the petitioner has realized that those ordinances were not proper.
and the
Maybe he has realized subsequently.
My lord,
And the
that is
majority judgment-
what he submits. That is what he submits, and that's why I'm saying that therefore his antecedents became a matter for consideration before this honorable court, that can a petitioner,
Yeah, but where is this admission?
Lord, it is there if your lordship will-
it is also mentioned in the judgment of
Yes, my lord, but if your lordship
the
will...
majority judgment, but they haven't gone beyond that.
Yes, my lord.
They've said that since that is no more a law, therefore they didn't consider it.
My lord, if your lordship may see it in the words of the petitioner himself, it is in part 1 of your lordship's intra-court appeal paper book, in paragraph 6 on page 121.
Paragraph?
Paragraph 6, page 121, part 1.
Padhiye.
My lord, that apart from the aforementioned amendments, there were certain amendments introduced in the NAO 1999 during the period when the PTI government was in power, but these had not been converted into an act as the efficacy and propriety thereof was being reviewed. However, before any final decision could be taken in respect of the said amendments which were introduced through 2 presidential ordinances, that is Ordinance number 23 of 2021 and Ordinance 26 of 2021, the government regime changed as noted above. Be that as it may, the incumbent government has retained these amendments with retrospective effect and subtle changes of expression, which too are being assailed in the instant petition as being ultra vires the Constitution.
Who has drafted this?
Khaja Haris, the council.
Isn't this a remarkable argument?
That was my...
I'm going to change the law of Pakistan through an ordinance, or rather through 2 ordinances, and I'm going to think whether this is appropriate or not afterwards.
My lord,
Is this a submission being made by Mr. Khwaja Haris?
My lord, I had before the 3-member bench used slightly more colorful language and said paragraph 6 is an example of the Wild West. Shoot first, ask questions later.
Whether
You make a law affecting the entire nation
whether
and
that-
then say you are thinking about it.
whether that
I would like to
ordinance
hear Mr. Khwaja Haris on this.
whether that ordinance had the retrospective effect or it was prospective.
Which ordinance, my lord?
The ordinance which the respondent has enacted.
My lord, they had not talked about retrospectivity, but may I point out?
Because he has an objection upon retrospectivity, not upon the.
No, everything. He had an objection on a number of provisions, not just retrospectivity. And the defense to retrospectivity very simply was this, that the NAB ordinance itself was with retrospective effect going back to 1985. So the amendments had to be made retrospective so as to have an effect.
Mr. Makhdoom Ali Khan, completely unrelated. Can we compel, since this will be a lopsided exercise,
My lord.
can we compel Senior Counsel Mr. Khwaja Haris to be in attendance and argue? Is it optional with him, or can we compel him? Because I don't want a lopsided contest.
We
You understand what I'm saying?
My lord.
I suggest we can invite him as an amicus.
No, amicus, so then he becomes a friend of the court.
Assist, let him be amicus this time.
Amicus is neutral.
Isme Makhdoom Saab,
Yes, my lord.
if my memory does not fail me, then when these ordinance,
No, but in a criminal matter, appoints counsel as well.
My lord,
Can we, okay, let's put it this way, amicus would be neutrality, which surely he can't be because he's a counsel for one party. But we can appoint him as counsel as well, to, in addition to what the respondent number one has to say, to assist respondent number one in formulating his submissions. And we can fix the fees for him as well.
if the respondent number one and the learned counsel agree, my lord,
will,
I don't know whether he agrees or not.
will the federal government agrees to pay his fee?
my lord, we will, Attorney General will speak for that.
No, whether you agree or not, we can compel you to do so.
It's very interesting if my memory does not fail me. When these ordinances were promulgated, at that time, the then government, including the respondent, had defended these ordinances on the ground that NAB had caused great damage to the economy and had also violated fundamental rights.
My lord, your lordship
And
is,
that is how they had defended it.
your lordship's memory is amazing.
No, no.
I had with my petition filed the press releases and video releases of the then finance minister,
जब वो छोड़िए,
of the then law minister saying the same thing.
लेकिन ये जरा दो ordinances तो दिखा दें हमें, ये जो आपने refer किए इस paragraph में, ordinance 23 and ordinance 26. Is it
I'll
on the
do that.
record?
Yes, sir.
If it's not, you can give us photocopies later.
My lord, I'll give your lordship the dates and I'll,
No, just show us which pages they are at.
my lord, National Accountability Amendment Ordinance 2019.
23 and 26 that has been referred to in this paragraph that you just read. Those two ordinances, can you just show?
Yes, my lord. Actually there were 5 ordinances and I'll draw your lordship attention to all of them. They are at pages 200 in part 2 of the ICA.
एक second.
And most of the amendments made by the parliament were in fact based on these ordinances.
Yes, my lord.
200.
Yes, my lord.
Makhdoom Saab,
Yes, sir.
some of them, most of them were based on these ordinances.
My lord, he says
The rest that I've gone through are based on judgments rendered either by the high courts or the Supreme Court.
Yes, and I had filed.
And that was, you see, to secure the fundamental rights of people who were being wronged.
And I had filed a chart, my lord, to show which amendment corresponded to the recommendations and directions of this honorable court. I had also, and so far as your lordship's other observation is concerned, your lordship is right, but he himself says that the government has retained these amendments. He is not saying, with subtle changes of expression.
It says that section 1, subsection 2, it shall come into force at once.
Yes.
It is not retrospectively.
Yes. The two, yes, my lord, and to the 2 ordinances which my lord the Chief Justice was referring to,
So
they are on page 210.
There are, you said 5.
Sir, the total are 5, but the 2 which your lordship pointed out, they are at page 210, which is ordinance number 23.
210.
And the other one which you
26 or 29, है ना?
23 है sir.
23 and 26. Sir.
23 and the 26, my lord, is on page 222. And if your lordship will see on page 23, my lord, Mr. Mandukhil, this was given retrospective effect, but a different date in section 1, subsection 2, shall be deemed to have taken effect on and from the 6th day of October 2021. So they backdate this one slightly. So they're not.
Your argument is you were on the same page.
Yes, my lord. Yes, my
You
lord.
were on the same page.
And my further submission is that this pleading was not inadvertent, because when the court gave them permission to file an amended petition, almost a few months down the road, they filed an amended petition in which they reproduced this paragraph verbatim.
Okay, now can you just run through all the
Yes, my lord.
ordinances
So-
that were done? We have one at do in seriatim order. The ordinances.
The ordinances, my lord, yes.
You referred to two, but you said there are more.
Yes, my lord.
Can we go in chronological order?
Yes, my
Earlier
lord.
in time or later? in
Yes, my
time?
lord. The National Accountability Amendment.
Page bataiye.
My lord, page 200.
This is the first one.
Yes, my lord.
Shall
First
we
one.
call it the first amendment?
Yes, my
ordinance? Okay, this is the first. Second one, kahan hai?
My lord, the second one is at page 202.
This is the second. Okay, now where's
Yes.
the third?
My lord, the third one is at page 210.
Third. Take fourth.
Sorry, 206, my lord. The 206 to 207.
206 is the third.
Yes, my lord. 206 to 207.
Take.
The fourth is 210 to 221.
This is the fourth.
Yes, ma'am.
Right.
And the fifth, my lord, is 30th, that is page 222 to 225.
Khadum sahab, 208 पे भी है, 20 of 21.
Yes, my lord.
नहीं वो act है. Act.
Gee, that became an act, my lord.
वो acting.
There's only one of these ordinances became an act.
So there are 5 ordinances.
Yes, my lord.
Can you read the provision on ordinances in the Constitution?
Article 89, my lord.
I mean, is it something the president should do on the spur of the moment or after careful consideration or it's silent?
My lord, the president accept
Article क्या पढ़ रहे हैं?
Article 89. The president may, except when the Senate or National Assembly is in session, if satisfied that circumstances exist which render it necessary to take immediate action,
If satisfied,
that circumstances exist which render it necessary to take immediate action, make and promulgate an
are
ordinance.
these words of any consequence or not?
My lord, I would say that they are.
No, because the way the ordinances are churned out sometimes,
Yes.
it seems it is not in conformity with the constitutional provision, which
Yes.
says, if satisfied, and then the president should mention, these are the circumstances where I must legislate now, though I have no legislative power. The legislative power vests in the Senate and the National Assembly. We have to do it today because of this reason. But I see ordinances which just do it as a matter of right. That is my inherent God-given right to do so. I've always wondered why they're not reading the language of the Constitution.
Your lordship is absolutely.
I mean, I may be wrong, so I just
No,
want
your lordship is absolutely right. Almost every government has ignored the provisions of Article 89. They wait for the National Assembly to
No,
go
that's
out of
just one
session.
condition. Now there may be something, I don't know, the government may need money or they may need I don't know, there can be genuine emergencies where you can't convene the National Assembly. So that is one condition. The other condition is his personal satisfaction. Okay, we leave that aside. The third one is the important one, which is circumstances.
Which render it necessary to take immediate action.
And now this is something which should not be discarded.
In the context of these ordinances, the explanation that given was that there is an urgency because the bureaucracy are, you see, the victims of abuse of NAB. So abuse of NAB even was acknowledged as a ground to bring about these changes. So, I mean, most of the amendments that were challenged were part of these ordinances.
Yes, they were. Yes, they were, my lord. And that was my submission, that this is why it is an extraordinary case in common law constitutional history that a person who has enacted the legislation when no longer in power was challenging that legislation before the Supreme Court. And therefore, one, your lordships can look at the antecedents of the petitioner in these circumstances. And second, he had no locus standi to do that.
Even the president was satisfied from that ordinance. That's why it was promulgated.
My lord, your lordship will see that when
Does the court have to issue him notice? the then president, and ask him whether he was satisfied.
My lord, when
Where did he record his satisfaction?
my lord, he did not.
Can we see the ordinances? What are the shape of the ordinances?
My lord, may I point out that
Zara padhte hain, where it is it expedient? Zara dekhein. The president is satisfied that circumstances exist which render it necessary to take immediate action. So he just verbatim reproduce the language without saying what are these
and
circumstances.
it's the same everywhere.
Makhdoom Saab,
My lord.
I think by now it is absolutely clear that NAB has always been used from its inception for political engineering. And it had extensively abused its powers. Now, even then government knew that. And that is why they wanted to bring about some changes to protect the bureaucracy. So, and all that they left were the elected representatives who were the victims. I mean, no one can compensate them for the irreparable damage that has been caused to them. Most of them, you see, were, I mean, with great respect. And now there's a plethora of evidence for that. How you see they were imprisoned, how they were humiliated, and ultimately they found out that there was nothing against them. So, I mean, it's a law. I don't know whether in the first place should be there or not. But these ordinances, even they were compelled to issue these ordinances.
Yes, my lord. And that was the justification given in the public domain.
Well, Mr. Makhdoom Ali Khan, that's, I would say, that's speculation. I mean, the language doesn't say that I'm doing it for this purpose. So
My
let's
lord,
stick to the language, but the president has to at least say, but this circumstance is immediate. I mean, whatever we are going now to intent, it's malafide or bona fide, but on the face of it, he's not stating what is what is necessary to take immediate action. That this is the reason why I'm doing it.
This was for the government to place before the president that these were the circumstances on the basis of which we are proposing the ordinance. And if the president is satisfied, then the ordinance has to be accepted.
My lord, I'm not.
And one thing more, whether the respondent is behind the bar, whether under any provision of the NAB ordinance, he is also facing the miseries of that ordinance.
Yes, my lord. Yes, that's correct. So,
Makhdoom Saab, is there any data which would show the damage caused by NAB to the economy, to the freedoms of the individuals, and by violating their fundamental rights? I think by now there must be a lot of data.
my lord, there are some judgments of this honorable court. There were a couple of reports which were also
Are you
placed.
now arguing that the entire NAB ordinance is illegal?
No, my lord, my
So, but
submission.
if you are saying this,
No.
then I assume you're saying
My submission at that time was.
no, abhi.
अभी नहीं, अभी भी सर ये है
आप सिर्फ एक ब्रिगेडियर असद मुनीर का suicide note देख लीजिए. That is sufficient. No one can bring back Brigadier Asad Munir.
my lord,
But he left with that. I think that should be brought on record. And I mean, I think that for NAB, speaking for myself, I don't know whether NAB is still abusing its powers or not.
my lord, my submission was on the constitutional plane slightly different. My submission was that this is first about the antecedents, then this is also a unique litigation. Citizens usually come to this honorable court or go to the high court to challenge that a particular statute is too rigorous and is too disproportionate, that it violates the fundamental rights to dignity, the right not to be tortured, the right to life. This is the first time when the statute, the rigors of a provision of a penal statute were reduced. And a person came forward and said, reduction in penalties.
So I have the very uncharitable task of interrupting because I want to make progress.
My lord,
We
yes.
would love to hear you, but today's date was propositions.
My lord,
So can you just, because this benefit of these arguments should be made when this one number one can hear them.
my lord,
So can we come back to, sorry, I have
No, not at all, my lord.
have this,
this is very,
a task which I don't cherish, but as the head of the bench, I have to do it. I want to keep you on track. Please cite the propositions.
it's very welcome relief, my lord, and I'm grateful to your
also-
lordship for that. May I say,
Makhdoom Saab, there is also a possibility that the respondent may want to strike down or request striking down the entire law. Now he is the victim.
my lord, the first
जब
proposition,
वो petition आएगी हम देख लेंगे.
first proposition related to these proceedings before the bench being quorum non judice in
हाँ, ये
view
तो
of-
हो गया आपका argument. हाँ.
The second was the maintainability of the petition in view of the judgment of this honorable court in Benazir Bhutto and dependency of the petition in Islamabad High Court.
ठीक.
The third submission was the antecedents of the petitioner himself
ठीक.
having promulgated these ordinances, then subsequently challenging. Fourthly, the locus standi of the petitioner. There was not a word in the petition.
Do
that-
you, for challenging a law, do you need locus standi?
My lord, my submission is that you need to have some standing, otherwise it will become a situation which is this honorable court has always avoided.
No, but 184 doesn't say that.
True, my lord.
Any matter of public importance seeking enforcement of fundamental rights.
Yes.
You can knock out the petitioner on these grounds, but can you say you don't have a locus standi? He may say whole of Pakistan is affected. So
My submission was that this was a purely
locus standi you need in 199, not in 184.
but even in 184, your lordship will not decide a purely academic or political
So it's not
controversy.
academic.
Makhdoom Saab, adding to
sorry.
what my lord has stated, 184.3 is discretionary.
My lord.
We have 57,000 pending petitions here. So why should this court consume the other litigants' time in a matter, you see, where the bona fides of the petitioner we are not satisfied with it, and the matter is also pending before the high courts. Now here in this case, as my lord Justice Mansoor Ali Shah has observed, that you see they were part of the parliament, they could have contested this. So absolutely I agree with my lord that these are important questions which must be addressed.
Those will come, my lord, regarding to antecedents, bona fide and standing. These three will get a bit conflated, but they will have to be taken together. His antecedents, his bona fide, and his standing, because it was also
It's
shown.
also very important. It's those 57,000 litigants in this court. Their time is being consumed. So if the matters can be resolved or decided by the high courts, why should this court take the time of other litigants?
The next submission made, my lord, after the bona fides was that there was no actual case or controversy before this honorable court. No,
What does that mean?
my lord, no order passed on the basis of these laws was being challenged. No proceedings which were taking place.
Is it necessary to challenge the act?
My lord,
Before challenging the act, there must be some order.
my lord,
The order was actually passed.
your
The
lordship
cases
has
were transferred.
your lordship has made a test, and the test which your lordships have articulated it, that where a challenge is made to a statute, that challenge can be made on two bases. One, the statute in its operation affects the rights of a person, or the statute is ex facie discriminatory. In the second situation, you must show that you do not have to wait for the operation of the statute. You must show that on the face of it, this
Okay,
statute.
we are noting your proposition. You will expand later.
Yes,
The
ma'am.
next proposition.
And therefore, and there was nothing which showed that the statute was ex facie discriminatory.
Don't make me more unpopular.
My lord. Next proposition. Next proposition was that this honorable court, in a series of judgments, have said that before striking down any statute, the court must place the statute next to the constitution. It must presume that it is valid and try to find every reason for its validity.
ठीक.
And only when that fails must the statute be struck down.
Next.
And this was neither addressed in the submissions nor pleaded. Next submission was that a statute which reduces the rigors of the law cannot be violative of the fundamental rights of the citizens of the country because it is to their advantage and not to their detriment.
ठीक.
Next, my lord, was that a retrospective legislation is not forbidden by the constitution. In fact,
Is it retrospective in substance or in procedure? Or both?
my lord, in this particular case, the punishment was not retrospective, the relief was retrospective. So it will not be hit by Article 12 of the constitution.
So retrospective relief is permissible.
Permissible, because the bar under Article 12 is to punishment of an act or omission which was not an offense at the time of the commission of the offense. And therefore, the statute will not operate retrospective.
That's it.
And that none of the fundamental rights in this particular case were violated.
Is there any mention in the petition, Mr. Mohdum, is there any mention in the petition that which provision of the act is in violation of which provision of the constitution?
No, my lord. And I had read out the entire petition before this honorable court to show that that challenge was not made. I had also submitted, and that's virtually the last proposition, my lord, that a number of these amendments were made in order to give effect to the judgments of the superior courts themselves. And all those judgments were placed on record. And with great respect, none of them were dealt with.
Is that your last proposition?
My lord.
I think, just to point out, going through the majority judgment, there are two very crucial questions. One question is that the majority judgment says that the limit that has been increased, that the threshold of 500 million, that could not have been done because the superior courts had laid down a threshold of rupees 100.
Well, 100 million.
So the superior courts do not have any power to legislate. So if the legislature has legislated despite there being a judgment, see, that could not have been a ground to strike down that law.
My lord,
then second, the main question, I think, addressed by Justice Mansoor Ali Shah, his lordship, in his dissenting opinion, was that all those references which were returned were also tribal before other courts under particular laws. And that is something I don't know whether the majority judgment had overlooked that or they were not properly assisted, but they struck down the amendments only on that ground.
My lord, may submit, your lordship has articulated it much better than I could. I was proposing to deal with this aspect as part of fundamental rights, that if the penalty is reduced, if the threshold is reduced from 500 million to 100 million, it does not violate any fundamental right.
Before you expand on this argument, where is this 100 million, first of all?
My lord, it is...
500 million has come in the statute. Where is the 100 million?
My lord, it was in the SOPs of NAB itself, in their standing operating...
That was accepted. That was accepted
upheld by this court.
Yes.
So that is why you see...
Without legislation.
Yes.
Without legislation.
And
this is by legislation.
So this is an argument which will have...
So my lord is, I think what my lord is saying, if I've understood my lord correctly, is SOP has given a higher standing than a legislative instrument.
My lord, yes, my lord. So this is addressed in two parts, much better in your lordship's observation, that this is an proposition or this is a finding which offends against the very principle of trichotomy of powers, because this was a legislative function, and even if the court has given a policy indication that where there was no threshold, that came in, my lord, at a time when NAB was prosecuting really petty offences that should at least look at 100 million. That was probably the floor, not the ceiling. And if the legislature has come up with a limit of 500 million, that's in the policy domain. Your lordship will see.
Mr. Makhdoom Khan, this is the only part of the amendment which I personally have difficulty bringing my head around, because you begin investigating a matter and it says 1,000 million loss has been caused. And you investigate it more, it goes down to 800, then it goes to 500, then it goes to 200, then you throw it away and say, oh, I don't have jurisdiction. So is there any other country in the world where we fix a threshold? Or when the trial starts, let's suppose this is a challan, and now the trial court comes to the conclusion that no, it's actually not 500 million, it's 490 million. It's bereft of, what does it do? So this thing, fixing an amount, sometimes you don't know, because it may be accounted for during the either during the investigation or during the trial. So are there any, you may just keep it, don't respond to it, and respond whether any other country or any other statute does these thresholds.
My lord, yes. I'm very grateful
Sorry,
for that.
Makhdoom Saab, I think the majority judgment answers this itself by saying that NAB only deals with mega corruption
Yes.
issues.
But no, but where do, I'm talking about the mechanism part of
And
it.
I had, my lord, given an example from the Balochistan High Court, that when the Balochistan High Court reprimanded NAB for prosecuting petty offences and said you should be doing better things, the defense of NAB was that there is no major corruption in Balochistan. If we don't prosecute these people, we would be left with nothing to do. So that is, my lord, Mr. Justice Mandukhel's judgment, and your lordship has noted that this is what NAB's extraordinary response was. And my lord, connected to 500 million and your lordship's observation, my lord, the Chief Justice, is the issue of forum. It was
No, I'm just saying the concept.
Yes, my lord.
You need not respond to
No,
it now.
no, my
This
lord,
is not really a contention, just for you
I'm
to
just-
respond later, if you want to.
Giving a proposition which is that there can be no fundamental right in the choice of forum. If the legislature thinks that some offences are better prosecuted by the accountability court, there are other offences.
We've understood that point of view.
Prevention of Corruption
Well,
Act.
I've understood that point
Thank
of
you,
yours. But the point which I'm saying is, should, there's a question mark at the end, legislature mention amounts when during investigation you really don't know. After investigation you know, and then during trial, if the amount falls short, he will say at the end, facing a hold, because of a trial, you say no, now he's to be tried by in another court. So I just want this to
My
raise
lord,
this query.
that's a very pithy observation.
No, but
and
are there any other precedents of this kind of legislation in Pakistan or elsewhere,
my lord,
where an amount has predetermined? Only after investigation you know the amount, because someone may make an allegation, जिसने करोड़ों खा लिए, बाद में मालूम हुआ कि जी वो 10 लाख थे. अब कुछ भी हो सकता है ना.
और एक और यहाँ पे क्यों
my lord, is done in fiscal matters. I am not aware of anything in criminal law, but I will research it. I will research it.
इसमें
साहब इसमें भी
मखदूम
देख
साहब,
लेना कि आप इसमें क्या सिंगल एक इदारा क्यों नहीं हो सकता? क्या गवर्नमेंट इस तरफ नहीं सोच सकती सिंगल इदारा हो, ये ना हो कि नैब का है, ये एफआई है,
My
ये
lord,
फलाना है.
my respectful submission was that before the Ehtisab laws as such, there were other laws in the country and before the NAB ordinance, there were other laws in the country which dealt with corruption. So simply referring some of the matters to those fora could not be violated of fundamental right. In response, example was given of Proda and EBDO, which were special tribunals of this kind made for disqualifying elected persons. And the response to that was that Proda and EBDO has a very checkered history in our country, which has been used again for political engineering and political maneuvering. But this is definitely merits, my lord, serious consideration, even with the legislature, that whether there should be a limit at all of 500 million.
I think a very pertinent.
Yes, my lord. They should,
Makhdoom Saab, if you are able to satisfy us that those 35 references which were returned and which appears to be the concern of the majority are tribal before any other forum, then the entire judgment goes. And which has been answered by His Lordship Justice Mansoor Ali Shah. Because that is the sole ground on which these amendments have been struck down.
The dissent is a complete answer to that, and that this was an academic exercise, and that in fact on ground something very different was happening.
You have to satisfy us that there is a forum.
My lord, yes, and it was, that submission was made in writing. I'll take your lordship to that submission. Plus, my lord, Mr. Justice Mansoor Ali Shah identifies that in the case of Ule and in the case of Bangladesh, the statutory provision was different. And their lordships have followed the judgment from India and Bangladesh without looking at the language of their statute. And that is, my lord, also what Mr. Justice Syed Mansoor Ali Shah points out in his dissent, and that's probably the last proposition, that the distinction which was drawn between elected holders of a public office and persons in the service of Pakistan, that distinction actually did not exist in law. And that's the last submission, which basically...
Sorry, come again.
My lord, that is articulated, my lord, also as point of law number 4 in my petition.
So just say it.
The distinction drawn in the majority judgment between elected holders of public office and persons in the service of Pakistan did not have any constitutional basis or statutory backing, because it is absent in both places. So virtually the lordships were saying that people who are politicians, they should be held to a different standard before a different forum. And so far as the bureaucrats and the others are concerned, there should be a different forum and a different standard.
And some others should be above the law.
They didn't go that far, my lord, but...
And please don't...
That's very important.
Please don't quote Animal Farm now. एक चीज जो which is I've been thinking may not have anything to do with this case. The scheme of the Constitution, as I understand it, criminal law, there are the provinces. The offenses are always tried by the provinces. And then there's a federation where you have to come up with something federal, FIA, money, banks, income tax, companies. Does the NAB ordinance blur the distinction? Or there is no distinction? Or is it permissible to legislate? I don't know if this has been considered. I don't think this has been considered.
No, it has
Maybe not be the question in this matter. Was it considered in Asfandiar Wali? You recollect?
In Asfandiar Wali, my lord,
understood the question?
There was, yes, my lord, there was some discussion, but eventually the lordships pointed out that while they upheld the law, they also laid down a number of safeguards. Which
No, I'm talking about the federal and the provincial scope of a law.
Yes, my lord.
Because the National Accountability Bureau is a federal organization.
My lord, yes.
It's not a provincial organization. Yes. It has, but it covers the provinces, corruption taking place in the province. Now, either it is money coming from the federation, then you can link it to a federal offense. Is this permissible? I just maybe leave this query. I don't know. I don't think this is part of this debate, but maybe may come up.
My lord, I appreciate my lord's question. It's a very, very pertinent question.
My lord,
especially, you see, in context of provincial autonomy.
Yes.
That isn't it an encroachment on provincial autonomy? I think a valid.
I don't know. I always wondered why this is so.
At the time of Asfandiar Wali,
हमारे साथ मखदूम साहब एक बड़ा मसला होता है आशुरा लगता है नैब ऑर्डिनेंस 2 मिनट में बन जाता है अगर कोई जमहूरियत कोई उस पे आगे चीजें करे वो बड़ा मुश्किल हो जाता है भाई वो तो फौरन आ गया ठक करके वो कोई क्वेश्चन नहीं किया अच्छा सपोज this is just another thing. What if ये तो उन्होंने changes किए? What if the government had thrown out the say be hereby NAB whatever ordinance is hereby repealed?
My lord, that was a
Could they have
submission.
done that or not?
My lord,
Whether
that
Without providing an alternative forum, could the legislator do that or not?
absolutely.
and whether they have the power to do so.
My lord, yes.
Not
A legislature which makes a law can repeal the law. And my lord, your lordships,
But if this is so, then the amendments fade into insignificance.
yes, they absolutely do. And
Are you sure you're saying this?
And absolutely, my lord, dissent takes care of it. And the submission made at the bar was that there is no precedent available where the court has struck down a law which has repealed an earlier penal law, because that would mean then all subsequent prosecutions will take place in the name of the court, because now this would be a court ordained or ordered prosecution, because the legislature is of the view that this penal statute should no longer be on the books. My lord, an example given was that if one goes back a few hundred years, there were more than 1,000 offenses for which people could be punished to death in the United Kingdom and in the European countries. And now capital punishment has been abolished altogether. Now this is a policy matter.
लेकिन मखदूम साहब जो 1999 से नैब की परफॉर्मेंस इंटेंट या कॉन्डक्ट रहा है, it should not have even existed.
My lord, and
जितनी फंडामेंटल राइट्स की वायलेशन नैब की वजह से हुई है, and very very unfortunately this court laid down law where virtually it had become impossible at one time to grant bails to the accused. जितनी फंडामेंटल राइट्स की वायलेशन इस नैब लॉ की वजह से हुई है, even if it had been struck down, I don't think, probably that may have been justified.
And my lord, the submission is, if the legislature can make a law and if the legislature can repeal a law, then where is the constitutional infringement when the legislature amends that law within the
The way
constitution?
my lord has already made it clear that SOPs were given preference
Yes, they were.
over legislative because there's parliamentary supremacy.
And your lordship will have to look at this law now through a different lens as well, because at the time of Asfandyar Wali, my lord, there was a concurrent list where criminal law and criminal procedure was all part of the concurrent list. Now there is no concurrent list.
After 18th Amendment.
Now we're limited to 140, what,
142. And
ठीक.
therefore, except for the limited scope of that
जरा एक
provision,
नजर पढ़ लेते हैं वो 140 क्या है?
my lord, that is 142 B. No. नहीं यार. Criminal law. Yes. My lord, subject to the constitution, Majlis-e-Shura Parliament and a provincial assembly shall have power to make laws with respect to criminal law, criminal procedure and evidence.
So if tomorrow any province makes law in respect of the crime against money crime or other corruption related crimes, the province can do so.
It can do so. And your lordship will see the federation, when the federation wants to do it.
इसमें I think जो 18th Amendment के बाद probably, as I correctly recall, Articles 142, 143 would be relevant.
Yes.
That in criminal law, matters or procedure, the Majlis-e-Shura's law will prevail.
My lord, that's the provision I was reading, 142B, which talks that both will have the power. And under 143, if there's an inconsistency between a federal and a provincial law,
As my,
the federal
lord
law
has,
will prevail.
as my lord has rightly pointed out, the parliament was competent to strike down or repeal the entire law.
Yes, it was.
It wouldn't have affected anyone's fundamental rights.
No, my lord. It
I
was not.
questioned, I did not point out. I posed a question, let it not be said, that I'll reserve for later. But
Paragraph 30 of the
ये
dissent.
जो federal legislative list है, अगर या तो we read Article 142 on its own, separately, entirely standalone,
My lord.
that anybody can do anything. Or we have to read it in terms of something related to the federation that I don't know. I'm leaving another query for you on the criminal law aspect.
Thank you, my lord.
Because it's made, for instance, State Bank of Pakistan, then okay, all money matters federation. But it raises larger questions. Maybe we should not raise questions which were not before the earlier bench.
That's
May it not be fair. I think maybe not correct. Chale, theek hai, okay. So these are your submissions?
My lord, these are.
ये NAB bureau जो है, is it answerable to anybody in this country?
My lord, it was required to make reports, and those reports were placed before Parliament, and it was placed under a ministry. Firstly, it was Interior, then thereafter it was Law. So the doctrine of ministerial responsibility comes in, but that's about it.
So it is not answerable to anybody.
इस पे असिस्ट जरूर कर दीजिएगा। ये जो माय लॉर्ड ने क्वेश्चन रेज किया, आपने सोच लीजिएगा। लेकिन ये सोचें, corruption is a problem. NAB has completely failed. It has consistently been used for political engineering. What is the solution? I mean, the parliament is supreme. And now you see if they make amendments to at least जो wrongs हुई हैं उनको ठीक करने के लिए, is that sufficient? I don't know. I mean, it's for the parliament to see.
Then yes, otherwise we go again into the legislative and policy domain. My lord, your lordship's observation, section 33D of NAB requires them to submit annual reports to parliament.
Simply submission of
Yes,
report
my
does not mean that they are under anybody. But actually they are, I don't know if they are under whom, under whose,
under the
controlling that.
under the rules of business, they are under the Ministry of Law.
इसमें एक और, to put it, you see, someone who had been wrongfully detained, and that person for a year or 2 years or 3 years, because of the law laid down by this court as well, an innocent person who could not get relief and the freedom, you see, and he remained incarcerated. Ultimately, when he's found to be innocent, can he sue NAB? ये भी सोच लीजिएगा.
The tort of malicious prosecution is there.
Article 212 पे
जी सर, वो ट्राइब्यूनल कोई नहीं है, लेकिन
नहीं, I mean, I don't know, in my note I've held
I know
that they can still prosecute you. See.
yes. Even in the civil law, the tort, the remedy in tort is there, but nobody really pursues it, and there are other reasons for that.
वो कहते हैं जान छूट गई, अब क्या पीछे पड़ना है कि फिर कोई और मसला निकाल.
We are too well mannered to sue the government in tort.
बहुत सारी स्टेटमेंट्स आई हैं रिगार्डिंग नैब. ठीक है, अगर आप हमें कहा है कि सेक्शन 33D का भी तस्करा हुआ है कि आपको रिपोर्ट देना होती है, अगर आप हमें एक पेन पिक्चर सिर्फ अगर दे दें, फाइल कर दें कंसाइज स्टेटमेंट. माय लॉर्ड हैज आल्सो रेज्ड अ नंबर ऑफ क्वेश्चंस कि एवरी ईयर आपके दायरे पे पैसे कितने खर्च होते हैं, आपकी रिकवरी कितनी होती है, ठीक है, और ये पैसे जाते कहाँ हैं,
आपका शेयर उसमें
ये आपको मिलते हैं या फेडरल एक्सचेकर में जाते हैं, ठीक है. ये आप एक कंसाइज स्टेटमेंट, बिकॉज वी डोंट वांट टू कंडेम यू विदाउट हियरिंग योर वर्जन एट ऑल. सो ये आपको आप मौका दे रहे हैं कि ये आप बुनियादी बातें हमें बता दीजिए, ठीक है, लिख कर दीजिएगा, ठीक है. The other, Mr. Farooq Naik, do you want to add to the submissions?
NAB से NAB काइंडली आप स्टैटिस्टिक्स दे दीजिएगा कि पिछले 10 सालों से कितने पॉलिटिशियंस को आपने प्रोसिक्यूट किया, कितने अरसे उनको अंदर रखा, कितने कन्विक्ट हुए और कितने अल्टीमेटली वर डिक्लेयर्ड एज इनोसेंट.
फिर ये भी बता दीजिएगा किस पार्टी में थे और फिर कौन सी पार्टी ज्वाइन कर ली, ये भी पूछना.
नहीं, दिस इज वेरी इंपॉर्टेंट. आपका
जो मेन पिटीशन थी
कन्विक्शन से पहले ज्वाइन किया कन्विक्शन.
और ये भी बता दीजिएगा कि आज क्या हुआ है. जब हम हाई कोर्ट में थे, बेल आती थी, आप सब आके जिस तरह अपोज करते थे, इवन प्रोटेक्टिव बेल्स, और उन्हीं के लिए आके फिर अब आप कहना शुरू कर देते हैं कि वी हैड नो केस एट ऑल. समवन हैज टू बी हेल्ड अकाउंटेबल.
don't worry, we won't hold you accountable.
Your Lordship, main petition
अच्छा
में मैंने
नहीं, फारूक
data-
नाइक साहब नहीं, आप बस नोट कीजिए.
Your Lordship
Do you
has
want to
raised a
add to the
query
proposition? Do you want to
regarding
add to the proposition?
I'll tell you. Your Lordship has raised a query regarding the malicious prosecution.
नहीं नहीं,
The amendment has
add
been
to the
made.
proposition. वो
Amendment
बाद में
has been
सुनेंगे
made.
आपको.
Proposition, the
Proposition
legal
जो उन्होंने
proposition
कही है,
have
कोई
all
आप
been.
add करना चाहते हैं?
They have stated very well by Mr. Makhdoom, and we will in the proposition, the legal and the constitutional proposition have been enunciated by Mr. Makhdoom Ali Khan, and we will dilate upon it.
Okay. कोई और
And the merits.
And
And the
who's the
merits.
third petitioner?
And
ये
the
कौन है?
merits.
वो है हमारे सामने. You are in which petition?
I'm number two of 23.
Two?
Three, sir.
नहीं, three. Zuhair Ahmed Siddiqui.
No, yes, Zuhair Ahmed Siddiqui.
Who's so Mohammed Zahid Imran?
I'm not aware of him.
आई नहीं है. अच्छा, और ये CMA क्या है? 9264.
My lord, these were the CMAs for interim relief. Now you had passed an order in paragraph number 5.
अरे ये वो है.
आपने वो फिर ये किया कि आप
नहीं, वो बरकरार रहेगा. अब जल्दी इसको खत्म
But
करते
उसमें
हैं.
एक अगर कर दे, I mean, obviously this order will apply to everyone who wants benefit of this order. But if there are people who want to have their trials conducted and proceeded and judgment be passed by those trial courts, at least permit them to make appropriate application and let the trial court then decide.
But then the question will be, if any such application comes from an affected party, आपके लिए तो ये फिर नहीं होगा ना. वो तो वो आके कहेगा जी मेरा ट्रायल कंप्लीट हो रहा था, आपने रुकवा दिया.
Right. So
या मुझे जजा मिले या सजा मिले.
Right.
अगर वो आपको क्या फर्क पड़ रहा है?
नहीं, हमें नहीं फर्क पड़ रहा है, but there are people who have reached out. वो ये कहते हैं कि जी हमारा case otherwise, I mean, there are accused persons.
We will inshallah wrap it up soon, the case. If they waited so long, wait a couple of weeks, inshallah.
आप चाहते हैं कि नैब आके कह दे कि ये we don't want to pursue further.
No.
आप withdraw करना चाहते हैं. बहुत से
नहीं, वो नैब नहीं, वो तो
हमारे सामने आए थे. 3 साल तक एक शख्स को जेल में रखा और यहाँ पे आके जब we have come to a conclusion that there no case is made out against him.
उसका तो I'm sure कोई बंदोबस्त सब आप करेंगे in proceedings में.
Yeah, I don't know if we can do it here.
किसी को जेल में बिठाने के बाद को
Attorney General Saab, there was a time where the high courts couldn't grant pre-arrest bail.
Right.
Because
right.
this court had laid down the law.
Yeah, ये ठीक है. ये
तो
ठीक कह रहे हैं आप.
लोगों के साथ जुल्म भी बहुत हुआ है. अब आपने ये सेटिस्फाई करने के आज तो नहीं हो रहा है.
नैब करेगी सर.
नहीं, आप
मैं तो
अपील आपकी तरफ से है.
I don't, but वो तो लॉ की constitutionality की हद तक है. Constitutionality.
अच्छा, इसमें लिखिए, with Mr. Makhdoom Ali Khan. Yeah, I want you to be here. So if we're getting the proposition, you want to articulate it as you want it.
एक चीज जरा आप just for my lord's.
हाँ, did you find out परसों तक हो जाएगा? वीडियो लिंक कैसे आप करेंगे वो आप अरेंज कर दीजिए.
जी सर, मैं I'll intimate day after tomorrow or the next day. मैं आपको भी intimate कर दूंगा.
नहीं, इंटीमेट क्या आप कर लीजिए ना, हम उसको फिक्स कर देते हैं केस को.
जैसे तरह
परसों हम कर देते हैं फिक्स.
ठीक.
क्या मुश्किल क्या, आप तो
वो
टेक्नोलॉजी
तो आपके पास तो है, वहाँ पे करनी है बात.
नहीं, आपको बस पता नहीं कैसे लिंक अप करेंगे. जैसे क्या जाके उधर लैपटॉप लगाना होगा, क्या लगाना होगा. जूम
We'll find out.
जूम तो वेरी सिंपल.
We'll find out, sir.
Your Honor, अगर इजाजत हो कि if the respondent number 1 we call in person, वो खुद आ जाए.
No, you are representing the provincial assembly, provincial government. Attorney General Saab, you have to ensure that it functions, the video link. Otherwise, the proceedings would have to be adjourned.
My lord. I understand.
So the onus is on you.
My lord.
So they won't be adjourned, there will be consequences.
Sorry. I
With my lord's permission. Otherwise, they'll take the easy way out.
My lord, उसमें एक चीज जो मैंने भी request की थी with respect to paragraph number 5. Now there might be cases where cases of no evidence, let's say, cases of no evidence before the trial courts. Now, if my lords are minded to conclude it in 2 weeks, which is
We
fine.
are every intention to do so as early as possible. I have to be away for a very
Yes.
short period of time.
That's right.
But-
That's what I had in mind. So therefore, if
Inshallah, we will. That's why we want to do it before, and then, I mean,
चले फिर अगर ये केस
और जितना-
conclude हो जाता है तो which is fine.
इसमें लिखिए.
बात नहीं होता. ठीक है. Next week.
ऑर्डर किधर? नहीं, वो लास्ट वाला ऑर्डर नहीं.
सर ये नीचे वाला
Notices were issued on the last date of hearing to the respondents. Respondent number one, is he the respondent number one in all the cases? Respondent number one, nahi, respondent number one in inter-court ICAs number 2 and 3 of 2023, and respondent number 3 in ICA number 4 of 2023, comma, namely Mr. Imran Ahmed Khan Niazi is presently confined in Central Jail, Rawalpindi, and was delivered certified copy of the order passed by this court and the paper books of the ICAs. Full stop. He has sought, in our order we had permitted him to be represented through counsel, but he has stated that he wants to personally argue the matter. Full stop. Full stop. The federal government, ये नीचे आपके आता है? ये रावलपिंडी जेल आपके नीचे आता है?
No, sir. So this is
The federal government and the government of Punjab
yes.
are accordingly directed to make arrangements to ensure that the said respondent can hear and address this court through video link. Cheek? Full stop. We note that the respondent number one, who had filed the petition, एक petition थी, Maghdum Sahab, एक petition थी?
Yes, madam.
Who had approached this court, was represented through a number of counsel, including senior counsel Khwaja Haris Ahmed. Full stop. We inquired from the advocate, the respondent number two. We inquired from the counsel representing. आप counsel हैं या office holder हैं? आपसे पूछ रहे हैं. हाँ.
I am additional prosecutor general.
We inquired from the additional prosecutor general of the National Accountability Bureau, bracket में कर दें NAB, whether he is supporting the appeals or opposing it. And he stated that NAB is supporting the appeals. Correct? Full stop. Notices had also been issued to the advocate generals of the provinces, and except the advocate general of Khyber Pakhtunkhwa, the other advocate general to TWO support the appeals. Full stop. Since to ensure that the matter is attended, that to ensure a proper hearing, And as respondent number 1 wants to address in person, we think it appropriate to issue notice to Learned Senior Counsel Khwaja Haris Ahmed, who had assisted this court in the same matter in the earlier round of litigation, to represent the respondent number 1. It is clarified that this does not mean that the respondent number 1 will not be able to address the court, but we expect Khwaja is to assist us on legal points. We want to clarify that respondent number 1, this does not mean the respondent number 1 will not be able to address the court. Full stop. In case senior counsel will only attend upon payment of fee, let him submit so, and the court will pass further orders in this regard afterwards. Full stop. We requested, Mr. Makhdoom Ali Khan has formulated the following propositions, which are also adopted by Mr. Farooq H. Naik, who appears for one of the other appellants. Do you want to add to the propositions, Attorney General?
No, I think it's covered everything, sir.
And as well as the Learned Attorney General for Pakistan and the Advocate Generals of the said three provinces who are supporting the appeals. Full stop. Represent करता है
Advocate General Islamabad से.
अच्छा वो कौन है?
वो अभी गए सर वो to inquire about the arrangements which had to be put in place.
What was his point of view?
Notice
So he accepts.
No, he's also supporting.
He supports.
तो उनका भी लिख दीजिएगा इस्लामाबाद वाले का. ठीक है. ये हो गया. अच्छा अब आपके propositions लिख रहे हैं. Colon. The majority judgment is a nullity in law as it was passed by an court. How would you like to frame it? Let's use your language.
It was passed by a bench of this court.
Which
was constituted in.
Which was not constituted in accordance with.
Which was not
constituted in accordance with Section 4 of the Supreme Court.
2, 3 and 4.
Section 2 and 4 of the Supreme Court within bracket Practice and Procedure bracket close Act 2023, and resultantly the same is quorum non judice.
My lord.
Full stop. The bracket में act कर रहे हैं. The act was enacted on 21 April 2023, and challenge thereto was thrown. वो किसने challenge किया था act? वो भी इन्हीं ने किया था respondent number 1 ने. Which the challenge to which was thrown, but most of its provisions, including Section 2 and 4, were upheld by this court. White judgment dated. Blank लिख दें, report हो गई है या नहीं? जी सर. Reported in, वो भी लिख दीजिएगा. हाँ? ये short order है long order है? Which the short order which the reported बताइए ना. अच्छा वो ऊपर लिख दीजिएगा reported में. अच्छा एक ये आपका contention हो गया full stop. Number 2 लिखिए. The challenge. The petition filed in this court, the constitutional petition filed by this court under Article 184(3) of the Constitution of the Islamic Republic of Pakistan within bracket Constitution bracket close was not maintainable in the light of the decision in the case of Benazir Bhutto का actual citation निकाल दें. Bracket में करने PRD 1988 Supreme Court 416.
It's Benazir Bhutto versus Federation of Pakistan and others.
Benazir Bhutto v Federation of Pakistan. ठीक है. Number 3 लिखिए. The amendments that were struck down, the amendments made to the National Accountability Bureau Ordinance, 1999, with a the National Accountability Bureau Amendment Act 2022, National Accountability Bureau within bracket Second Amendment bracket close Act 2022, and National Accountability Bureau within bracket Amendment Act 2023. ये तीन acts से struck down हुए थे.
My lord, that was the submission that they did not touch 2023 and struck down the two earlier statutes.
They were struck down in the entirety, these two acts?
No, certain provisions.
The provisions कर दीजिए, were struck down despite the fact that most or some of the amendments.
Some, few.
Which word would you like to use, most or some?
Some.
Many.
Okay. Many of the provisions of the amending acts had been borrowed from the ordinances enacted by the government of which respondent number 1 himself was the Prime Minister, comma, as under, colon. इसमें लिख दें, ordinance number Roman का ये 21 of 2019, bracket में कर दें, first amending ordinance, फिर लिखिए, number 2 में bracket में ordinance 20 Roman XXV11 27 of 2019, bracket में कर दें second amendment ordinance, फिर लिखिए ordinance number 5 Roman 5 of 2021, bracket में third amendment ordinance, amending ordinance, amendment ordinance, fourth लिखें ordinance number 23 of 2021, fourth, and ordinance number 26 of 2021, fifth. Bracket में कर दें at pages which have been filed in part 2 of the appeal. Bracket इसकी जरूरत नहीं है, चलें ये point हो गया. Full stop. Next लिखें. Can we club these three into one? Antecedents, bona fide, and locus standi?
Yes,
or you want to separately?
No, it can be clubbed in one.
The bona fide, the antecedents. The respondent number 1, bracket में कर दें, petitioner before the court in the constitution petition, bracket close, did not approach this court in a bona fide manner, and his antecedents prevented him from challenging the very acts which he had himself, which on his government's advice, the President of Pakistan had enacted as the above mentioned ordinances. Our locus standi ka kyun nahi? What was the ground on locus standi?
My lord,
And did not have locus standi because
he was not personally affected in any manner whatsoever.
Because none of the amendments brought through the amending acts personally affected
him or the public at large.
Or the public at large. ठीक है, full stop. Next paragraph, next point लिखिए. This court had carried out an academic exercise, and there was no actual controversy before it, in that no right of any person had been adversely affected.
My lord.
And what was the ex faci thing?
My lord, and this law was not ex faci discriminatory.
And nor were the amendments that had been made ex faci discriminatory. Is that correct? Shall we proceed to the next one? In the constitutional scheme, it is for Parliament to legislate, and the courts make every effort to uphold such legislation unless it can be pointed out that the same are unconstitutional. And if there are two views possible, the one in favor of upholding the legislation is to be preferred. Do you want to add, subtract?
No, my lord, this is absolutely fine.
Okay. The amendments had sought to reduce the rigors of the NAB, the prevailing NAB ordinance, and as such, a law the amending laws which sought to reduce the same could not be construed to be violative of fundamental rights under Article 184(3). Cheek?
Yes, my lord.
If you want to change anything, because they are your propositions.
No, my lord,
I'm just recording what I think I understood. And if I did not understand correctly, please feel free to intervene.
I'm grateful, my lord.
Retrospective relief.